When authority gets the law wrong, most people assume that when a judge speaks about gun laws, the information is accurate by default. After all, judges wear robes, hold gavels, and are trusted to interpret the law for the rest of us. But history shows something uncomfortable. Authority does not guarantee understanding. This story begins the way many controversies do, not with a courtroom ruling, but with a public statement. A confident declaration about public safety, firearms, and who should be allowed to carry them. At first glance, it sounded reasonable, responsible, even familiar. But buried inside that statement was a legal problem so serious that it exposed a deep misunderstanding of federal gun law. This is not about personalities or politics. This is about what happens when someone in power promotes a rule that federal law explicitly forbids, when rhetoric collides with statute, and when millions of lawful gun owners are told, incorrectly, that compliance is mandatory. Today, we break down the judge, the claim, the federal law she overlooked, and why this mistake matters far beyond one interview or one city. Section 1. The statement that sparked the fire. The controversy began with a simple claim that in Washington, D.C., handguns must be licensed and registered with local police in order to be lawfully carried. On the surface, that sounds like routine regulatory language. But to experienced firearms attorneys, that sentence immediately raised alarms. Why? Because registration is not a neutral word in gun law. Registration creates records. Records create centralized databases, and centralized databases of gun owners are something federal law has long forbidden. The problem was not tone, it was substance. The statement suggested that lawful carry required placing firearm and owner information into a government-controlled system. That implication alone runs directly into a federal prohibition that has existed for decades. And this is where the gap between assumption and law becomes dangerous, because when officials confidently state rules that do not legally exist, citizens are left choosing between compliance and constitutional rights. Key takeaways. Public statements by officials can still conflict with federal law. Gun registration is not a neutral concept under U.S. firearms law. Legal authority does not eliminate the need for statutory accuracy. Section 2. What federal law actually prohibits. Federal gun law does not leave this issue ambiguous. In fact, it addresses it with remarkable clarity. Under federal statute, neither the federal government nor the states may create a system that registers firearms, firearm owners, or firearm transactions. This prohibition was not accidental. It was deliberately written to prevent exactly the kind of centralized tracking systems that have historically preceded confiscation in other countries. Congress made a policy choice, regardless of political views, that lawful gun ownership would not be cataloged into registries controlled by government agencies. That law applies nationally. It does not disappear inside city limits. It does not become optional because a local government prefers stricter oversight. Federal law preempts conflicting state or municipal schemes when those schemes cross into prohibited territory. So, when an official implies that carrying a firearm requires registration with law enforcement, the legal issue is not interpretation. It is a contradiction. Key takeaways. Federal law expressly forbids gun owners and firearm registries. Local rules cannot override federal statutory bans. Registration requirements raise immediate preemption concerns. Section 3. Why this law exists at all. To understand why this statute matters, you have to understand the history behind it. The federal prohibition on registries was not passed quietly or casually. It was a response to real fears about abuse of records, mission creep, and the erosion of lawful ownership through paperwork rather than prohibition. Lawmakers recognize that once lists exist, pressure follows. First for compliance, then for justification, then for enforcement. Even without confiscation, registries chill lawful behavior by placing citizens under constant surveillance. That concern did not come from fringe voices. It came from bipartisan agreement that firearm ownership, unlike vehicle ownership, touches on a constitutional right. And constitutional rights do not require government permission slips to exist. This is why the law does not say registries are discouraged. It says they are prohibited. Key takeaways. Registry bans were enacted to prevent future abuse of records. Gun ownership is treated differently than licensed privileges. The statute reflects deliberate constitutional protection, not oversight. Section 4. The credibility problem. When someone claims to be a strong supporter of the Second Amendment while promoting rules that violate its statutory safeguards, credibility becomes the issue. Support is not measured by slogans. It is measured by familiarity with the law. This becomes especially troubling when the speaker is not a layperson, but a former prosecutor and judge. Someone who has applied these statutes in court. Someone expected to know the difference between lawful regulation and forbidden control mechanisms. Past statements and historical positions further complicate the picture. When public records show advocacy for expanding gun bans or extending expired restrictions, later claims of staunch support ring hollow. This is not about personal beliefs, it is about consistency between words, actions, and law. Key takeaways. Legal credibility depends on statutory knowledge, not labels. Prior advocacy can undermine present claims of support. Courts expect consistency between interpretation and application. Section 5. Why this matters nationwide. This controversy is not confined to one city or one judge. It highlights a larger national problem. Gun laws vary wildly across jurisdictions, creating traps for lawful owners who cross invisible borders. When officials misunderstand or misstate federal limits, the result is confusion, selective enforcement, and fear-driven compliance. People obey rules that do not legally exist simply because authority figures assert them. This is precisely why national reciprocity and clearer federal standards continue to gain attention, not to expand carry recklessly, but to ensure that lawful conduct in one jurisdiction does not become criminalized by misinformation in another. Knowledge, not confrontation, is the only protection in this environment. Key takeaways. Inconsistent enforcement creates legal traps for citizens. Misstatements by officials have real-world consequences. Clear national standards reduce confusion and rights erosion. Section 6. When federal law overrides local power. One of the most misunderstood concepts in American law is preemption. Many people assume that states and cities can regulate however they want, as long as they claim public safety. That assumption is wrong. Federal law sits at the top of the legal hierarchy. When Congress passes a statute within its constitutional authority, lower governments do not get to reinterpret it away. They must comply. Firearms regulation is one of those areas where Congress has spoken clearly, especially on the issue of registries. This means a city cannot do indirectly what it is forbidden from doing directly. It cannot rebrand registration as licensing. It cannot collect owner data under the guise of carry compliance, and it cannot require submission of records to law enforcement if those records function as a registry in practice. Courts have repeatedly ruled that substance matters more than labels. If a system tracks firearms or owners in a centralized database, it does not matter what officials call it. The legal effect is what controls. That is why statements implying mandatory firearm registration raise immediate red flags for constitutional lawyers. They suggest enforcement models that federal law has already rejected. Key takeaways? Federal law preempts conflicting state and local gun rules. Renaming registration does not make it lawful. Courts examine function, not government terminology. Section 7. The risk of selective enforcement. When laws are unclear or misstated, enforcement becomes selective by default. Officers rely on guidance from leadership, prosecutors rely on agency interpretation, and citizens are left guessing which version of the law will be applied to them. This creates a dangerous imbalance. Law-abiding individuals may comply with unlawful requirements out of fear, while enforcement agencies quietly expand their authority beyond legal limits. That imbalance erodes trust and undermines voluntary compliance. Selective enforcement also creates constitutional risk. When laws are enforced inconsistently, courts scrutinize intent. Was enforcement driven by safety or by ideology? Was compliance demanded universally or only from certain groups? These questions matter because constitutional violations do not require bad intent. They require unlawful action. And once rights are chilled, damage is already done even if no arrest occurs. This is why precision in public statements matters. When officials speak inaccurately, enforcement follows the error. Key takeaways. Legal ambiguity leads to selective enforcement. Citizens often comply with rules that are not lawful. Rights can be violated without arrests or prosecutions. Section 8. The pattern behind the mistake. This incident does not exist in isolation. It fits a larger pattern seen across the country after major Supreme Court rulings. Lower officials often resist changes in constitutional interpretation by narrowing, delaying, or reframing compliance. After landmark Second Amendment decisions, many jurisdictions attempted to preserve old systems by modifying language rather than substance. Permit schemes became licensing systems. Bans became feature restrictions. Registries became compliance databases. Each shift was designed to survive judicial scrutiny while preserving control. But federal law places hard limits on how far those adaptations can go. When officials ignore those limits, it is rarely because the law is unclear. More often, it is because compliance would require surrendering authority they are unwilling to relinquish. That tension explains why statements like this continue to surface, even decades after Congress settled the question. Key takeaways. Resistance to Supreme Court rulings is often structural, not accidental. Language changes are used to preserve regulatory control. Federal limits still apply regardless of local resistance. Section 9. Why knowledge is the only defense. For everyday gun owners, this situation reveals an uncomfortable truth. Your protection does not come from goodwill. It comes from knowledge. Police officers enforce what they are trained to enforce. Judges rule based on what is argued before them, and officials speak based on their own interpretations. None of that guarantees accuracy. That means responsibility shifts to the citizen, knowing where federal law draws lines, knowing when compliance is voluntary, knowing when a requirement exceeds lawful authority. This is not about confrontation. It is about restraint. Knowing when silence is safer than explanation, knowing when documentation matters, and knowing that asserting rights calmly is not hostility, it is literacy. In a legal environment this complex, ignorance is not neutral. It is exploitable. Key takeaways. Rights must be actively understood to be protected. Calm assertion is safer than emotional compliance. Legal literacy is a form of self-defense. Section 10. The bigger constitutional warning. The most troubling part of this story is not one incorrect statement. It is what that statement represents. When individuals entrusted with interpreting the law misunderstand core statutory protections, the system itself becomes unstable. Rights stop being guaranteed and start becoming privileges granted by officials who may not fully understand their limits. That is why constitutional rights are written down, not to empower officials but to restrain them, not to guide discretion but to limit it. Every erosion begins with normalization, a registry framed as safety, a requirement framed as compliance, a right framed as a conditional allowance. History shows that once those frames take hold, reversal becomes far harder than resistance. Key takeaways. Constitutional erosion often begins with normalization. Misstatements by officials weaken structural safeguards. Rights exist to restrain power, not accommodate it. Know the law before power redefines it. This story is not about personalities. It is about principles, about whether laws mean what they say or only what authorities claim they mean in the moment. Federal gun law is clear on registries. It has been clear for decades. When public officials contradict that clarity, the correct response is not outrage, but understanding. Understanding what the law actually says. Understanding where authority ends. And understanding that rights unexercised become rights eroded. If there is one lesson here, it is this. Do not outsource your constitutional knowledge. Not to politicians, not to agencies, and not even to judges. Because in a system built on law, knowing the law is the only thing that keeps it standing.